Hello, YouTube. I'm Vince White. I'm an employment attorney, and we are answering questions from comments on our YouTube channel today, getting people the answers they need. We have a question here from a friend of the channel, a very active commenter and poster who suggests a lot of potential stories for us, which is a huge help. Thank you, David. And here's what he has to say in his comment. I actually have something else to bring up here, and a specific question to ask. You mentioned with regard to retaliation that in some cases, someone may not know enough to report retaliation. For those who do know enough to report retaliation, and who can surely identify it was retaliation, isn't retaliation and the pretext behind retaliation typically pretty easy to prove? Okay, so under the federal law, and there's going to be some variation on the state and local laws, right? But under the federal law and many of the state and local laws, there is a burden shifting when you have a retaliation claim. Now, what does that mean? Well, I'm going to make the attorneys in the room scream when I say this, but the easiest way to think about it is if you have a discrimination claim or sexual harassment claim and you go to trial on that, on day one of the trial, you enter and the burden is on you. You as the plaintiff must prove I was the victim of discrimination in the workplace, or I was the victim of sexual harassment in the workplace. You are the ones making your case. You are the ones who have the burden of evidence, right? And now here's where we're going to make all the attorneys scream at this oversimplification. If you're going into court on a retaliation claim, right? A retaliation claim flowing from a complaint or an effort to oppose discrimination or sexual harassment in the workplace, there is a burden shifting. And the easiest way to think of it, cue all the screaming from all the attorneys, the easiest way to think of it as a layperson is the defendant enters court day one, guilty until proven innocent. That is how you should imagine it. That is an oversimplification, but it's how you should imagine it. They can go into court and prove their innocence. But on day one, the burden is on them. They are guilty till proven innocent. Their job is to get evidence out that proves they're innocent. That burden shifting is so rare in the U.S. system, and it's meant specifically to empower these retaliation claims, because we all know if retaliation is not stopped, right, if employers are not afraid to retaliate, then the discrimination claims that these laws provide can't go forward, because nobody will bring them, because everyone will know if I do this, I'm definitely losing my job. What a chilling effect, right? So that's why we need this burden shifting, and that is why, as David noted, these retaliation claims can actually be much easier to prove, and sometimes even way more valuable, right? So we have a lower risk claim in the form of retaliation, and it can be more valuable because you're activating that third class of damages, punitive damages. Retaliation claims can be lower risk, higher value than the underlying sexual harassment or discrimination claim. That's wild. It's incredibly useful. It's incredibly important, right? There's case law in New York that a supervisor making an involuntary mean face at someone who complained about him, he didn't even mean to. It was involuntary. That was an act of retaliation. Why? Because it could have a chilling effect. It could keep that person who complained from complaining in the future, right? That's incredible. That's important. These are the level of protections we need so employees can speak out. I can't. David, you're absolutely correct. Yes, retaliation claims can be much easier to prove and are a massive and extremely important tool in the toolbox of any employment attorney on the plaintiff's side, without a doubt. David, thank you for the question. Everyone, if this video helped you, please consider liking and subscribing. It helps me to help more people just like you. I will track the comments down below. You can tell me I'm right, I'm wrong. You can ask me questions. I'm going to try to answer the questions. And listen, everybody. Everybody works. Not everybody wins.